thank you very much. Thank you also very much to Marie and Eliana for your very interesting presentations. And thank you so much also for having the opportunity to talk today to you about our farmer project. And yes, maybe as already said, my name is Nora Katona, and I'm working at the Ludwig Boltzmann Institute of Fundamental and Human Rights in Austria, Vienna. And I was asked today to talk about our project Dignity at Trial, enhancing procedural rights of persons with psychosocial and intellectual disabilities in criminal proceedings. And this project was conducted between 2016 and 18, and it was basically before this project started. And so I was asked to give you a short overview about our main findings and outcomes. And I'm starting my presentation now. Exactly. So the Dignity at Trial project was also an EU-funded project, and it was taking place between 2016 and 2018. And the main aim of this project was to assess if the European Commission's recommendation on safeguards for vulnerable persons, suspects, or accused in criminal proceedings had any effect on the national laws in 5 partner countries, and also to really assess if the recommendation in itself as a non-binding instrument was sufficient to basically bring along change in specific areas. And we did this assessment and this project together with the Bulgarian Helsinki Committee in Bulgaria, the League of Human Rights from the Czech Republic, with the organization Mental Health Perspectives from Lithuania, and the Peace Institute from Slovenia. So we did in all these 5 countries national research, and basically afterwards we compared the results, and this all resulted in a handbook. So to show you a little bit the methodology, I will come back in a second. First, the scope of the project. So we only focused in this project on criminal proceedings, despite recognizing that of course there are also a lot of other areas of law that may interplay. But in this concrete proceeding, we were only in this project we were only focusing on criminal proceedings, meaning on the situation. Oh, sorry, it went too fast. I just try to. So basically from the moment the person is suspected of having committed a crime until the conclusion of the proceedings. So what was not included in this project is the preventive detentions or measures after there is a judgment, but of course what we have also closely looked at is accommodation when persons are in a compulsory treatment during the proceedings instead of a pre-trial. So basically, the whole project looked at the situation where persons are suspected and accused. And as already heard in the previous presentations, also in this project, the main anchor point was the effective participation. So also the recommendation itself has as a main entry point that it's focusing on persons in vulnerable situations who are not able to fully understand and to effectively participate in criminal proceedings. In this concrete project, we have agreed to look at adult persons with intellectual and psychosocial disabilities who, due to their disability, are hindered and to effectively participate in a criminal proceeding. The methodology of this project, as I've already mentioned, in the national level, we did some legal analysis, and we did interviews with experts and interviews with beneficiaries. In total, we had 110 interviews, thereof 63 with persons who experienced this procedure and had psychosocial or intellectual disabilities. So also to really hearing the experience and also really to assess how and what they would have needed during these proceedings, and also to understand the whole experience and also be able to give recommendations also from their perspective. In all national countries, we had an additional advisory board, that was composed of interdisciplinary experts. So in concrete, we tried to have in each and every country a member and a representative of a law enforcement authority, a representative of the judiciary, lawyers, also civil society representatives, medical experts, as well as also persons and experts by experience. So in some countries we managed, so there we had also this advisory board composed of this very interdisciplinary team who gave feedback on the outcomes of this project and also developed together with us the recommendations and other tools that I will just present in a second. Based on this national report, we established and we drafted the handbook. And the handbook also includes, of course, a comparative report on the 5 countries, also the experiences of persons with intellectual and or psychosocial disabilities, and also a first attempt for criteria for the identification and kind of a checklist for law enforcement authorities to really be able and have first indicators for persons' potential intellectual or psychosocial disability. In addition, we also, based on international and European human rights law, we tried to really highlight how an ideal procedure could look like and should look like, and also to really give it kind of a criteria for identifying good practice examples. And also, because it was mentioned already before, is this question of in how far is it really possible to understand this very complex legal proceedings. And due to that, we also drafted a documentation sheet that should be used in addition to the letter of rights to also really make it more accessible to persons who have psychosocial or intellectual disabilities. So I'm going to present some of the main findings, and I try to cluster them. And I'm also referring to a lot of aspects that were already mentioned by Deliane and Maria, just a little bit from a different angle. So what we have identified in our project as main gaps and also main findings, some of them concerns general aspects. The first of all, of course, is this was the main objective of our project, was to really see in how far the national criminal laws are in line with the recommendation. Here we can say that in all of these 5 countries, of course, all of them provide certain procedural safeguards, but none of them has really shown that all the recommendations foreseen in the European Commission's recommendations are really in place. So there are a lot of areas which are in the national laws are not covered and are not really implemented in a way as the recommendation foresees it. So of course, this is a levels decision, but of course, we in one of our main findings was that the recommendation in itself seems not enough to really be to really harmonize the laws and the national criminal laws in the member states, as it's a non-binding EU instrument. So the question is, would a directive change the situation? Of course, that we cannot answer, but of course it would be worth considering to really have a directive on the procedural safeguards for persons who are in a vulnerable situation. The terminology, definitions, and concepts here, again, I can in a lot of aspects I can refer back to Maria. So yes, there is no concept of vulnerable suspects in none of the participating countries. So if they are really talking about vulnerabilities, it very often refers to victims, but not to suspects. So the concept of vulnerable suspects or accused, as it's foreseen in the recommendation, is not consistently reflected in the national laws of the participating countries. The same is true to definition of disability. Only one of the 5 countries have adopted the definition of disability in accordance to the CRPD. All the other countries rather are using, when they are referring to disabilities, very outdated terminology, which are very discriminatory and also stigmatizing in a lot of ways. And also, when we're talking about the concept of vulnerability and recognizing suspects in being in a vulnerable situation, it's often that we are referring to persons in ways, and we are responding to the needs with a one-fits-all approach. So especially when it comes especially when it comes to the differentiation, as we have heard from Deliana, there between psychosocial and intellectual disabilities. So often the national laws are not really taking into account the differences, and also are not differentiating in the responses. So for example, giving Austria as a concrete example, when we are having an expert opinion, it's foreseen that it has to be a psychiatrist, and there is not an option and not an opportunity to maybe also have an additional expert opinion from a different area of expertise. And the same goes, of course, also once there is a final decision and a final judgment in how far the therapies that are provided during detention measures and preventive measures, in how far they're really fitting and suiting also the needs of persons with intellectual disabilities. So we have found that most of the responses, if there are any, are very going in a direction of one-fits-all approach. And this is also why I'm really happy to see also today's program, and also to learn more about the training, about the training module of this project, because also we have identified that there is a lack of training opportunities, and also especially when it comes to police officers, but also when it comes to other stakeholders like judges, prosecutors, penitentiary staff, and also lawyers, especially also when it comes to legal aid lawyers who might not have might not be specialized even on criminal law. So the lack of training of opportunities concretely meant in our research findings that only 2 out of 5 countries had a training for police officers at any point in their career, and none of them at this point had any training opportunities for judges who are already appointed. Maybe here I can give an example from Austria, because here in Austria they tried to really implement the training opportunity and also the trainings together, with meaning by in a way of a tandem training, meaning that there is always a practitioner, be it a police officer or a judge, because we now lately have these trainings, together with an expert by experience, which I think is an interesting and initiative way also and could be also considered for the future. Then also concerning as also this project, and also as was already mentioned at the very beginning of today, also we have found that one of the main challenges and the main shortcomings in this area of criminal law is the assessment. That often there, even if there are responses in place, they only come into play and into power once the disability and the vulnerable situation is identified. Nevertheless, there are no standardized assessment mechanisms or procedures for identifications in these 5 countries in place. So the identification depends widely on the knowledge and sensitivity of the individual representative of the authority, who either perceives signs or not, and according to them, the person, the representative of the authority, either requests an examination by a medical expert or not. And again, also here, corresponding to the findings of this project, is the practical challenges in identifying the disabilities in a timely manner. So oftentimes, disabilities are identified if they're obvious, if they are very visible. At the same time, frequently others which are less obvious and together with less obvious indications remain undiscovered. And this was also mentioned already before in the previous presentation, and that the reasons there might be various. But as long as the assessment is not done, often the other further procedural safeguards are not coming into power. And for that, to really have a first assessment together in our project, we have created a checklist, which is basically for the first indications for persons potentially intellectual and or psychosocial disabilities, This is targeting the law enforcement authorities, and it includes 3 main points. The first one is really the first screening for the police to really observe the behavior of the person, then also concrete questions for the suspect, and as a last point, if available, there should be further information should be gathered. This is a very brief checklist, and the reason why we have agreed together with the advisory group and the advisory board to really keep them as short and as precise is to really not to give the temptation that the police is doing afterwards an assessment, a medical assessment, him or herself. So the idea of this checklist is really to give a tool into the hand of the law enforcement authorities to really have the indications and to know when a medical expert should be involved in addition to really have a medical assessment, a proper medical assessment. And also the last part, the further indications that might be found. It's also very important in this regard to keep in mind the data protection laws, and also to really ensure that while we are saying that a timely identification is very important, not to forget that also the data protection plays a big and important role. Just to mention, in Austria, we used to have a directory before the computer times, but still there were really the informations of persons were collected at the police station, and this is something absolutely that should be absolutely avoided. And unfortunately, we don't have them anymore. And I think this is also the direction where we should not go back. Why the timely identification is so important, I tried to show you. I tried to show you it in a very concrete case. This is a case of Austria, and the person is living with an intellectual and psychosocial disability, and also in a supportive home. And the person had former experiences with the police and also was present at the questioning, supported by his person of trust. Then he was summoned to come to police interrogation, and at this police in this police station, the police was not aware about him having an intellectual psychosocial disability, and he went there alone this time, and the police interrogation was done without a third person involved. Why this is here again, the timely identification is so important, because if you look at the Austrian system, we do not have a general mandatory presence of a lawyer at the investigative phase. There is, of course, a right to a lawyer which can be waived. So in case the person is waiving this right, he is not represented. Although there would be a mandatory presence, but this requires that the vulnerability is identified. So all these safeguards and all these procedures only, and all these responses from the state are only really coming into force once the disability is identified. And this is why it's also really so important that this is done at a very, very early stage, because in this case, the person gave a confession without really being fully aware what consequences this might have for the proceedings. And in the proceedings, this confession was used also to come to a final judgment. So there was no possibility to really exclude the confession at this stage anymore. And the assessment, of course, we have talked a lot about this initial assessment, and at the same time, I think it's also very important to mention the experts, the medical expert opinions. However, seems to be challenging in some of the countries, either because persons have to wait for a very long time to get an expert opinion, or because the expert opinion's quality is not ensured. And also this is because there are no mechanisms in some of the countries to really ensure the quality, and also to be able to have a second expert opinion, except the court accepts this request. Then I have also some other findings which concerns not the assessment anymore, but once there is an identification or in general. So no, there is no information in an accessible format. Why this is important, we have already heard it before. I think most of you are aware about this very long and technical letters of informations in all countries available, and there are no accessible formats, meaning that there are no translations into plain language, but also oftentimes it's not available in Braille. So people and persons are confronted with this very technical, legally letter of rights. And what we have tried, and what we think is that next to the timely identification, one of the most important things is, of course, the information, that persons are informed. And that's why we have translated the letter of rights in a plain language together with an expert of plain language to really try to make them more accessible. Of course, this cannot replace the letter of rights and should not replace it, but it could be used in addition, and mainly and especially what was very important while having this idea was that this documentation sheet should be filled out together with the authorities. Here's the example. This is only the first page. So we have drafted this one for the police and also for the judges. So it includes the description of the right and also concrete questions where persons can decide yes or no. And as already indicated, this should be filled out together with the authority. Also, in our findings, we have found that although in all of the countries, legal representation is mandatory at the police station once it is identified, that in the interviews we had, in most of the cases, persons had the questionings and the interrogations without an appropriate adult legal representatives or lawyer present during the police interrogation. Here again, the question, of course, is the timely identification. And this is especially burdening because when we have talked to the persons concerned, all of them and the most wanted recommendation, and what they really wanted the most was to really have a person of trust throughout the proceedings. And this was mentioned again and again, that this was the thing that they missed the most during proceedings when they had to go through this whole experience on their own. And the European Commission's recommendations also foresees the interrogations and the audiovisual recording of interrogations and hearings, and this is not done in any of the countries when we did the research. Why this is important, and also at the same time recognizing that this might not be the ideal scenario for all of the persons, but of course it first of all is preventing any misuse of power, and of course, and mainly, this could also be used as in the context when there is an appeal or a remedy. And then I'm coming already to the last point, and this concerns the trial phase. And I think we are going to hear a lot about it in the afternoon, so maybe just I will also keep it very brief. But we have also identified that in most of the cases for persons concerned, it was not possible to really effectively participate in the proceedings. The grounds are numerous, as also already some were mentioned in the presentation before. Some of the persons concerned had difficulties in understanding the proceedings and following the trial due to the legal language, to the velocity of speaking, and in the overall challenging situation for the persons. So what was also mentioned, that linked to that, many of the persons could not understand the court decisions. So they went out of the courtroom, and in the end, they were not aware of what is going to happen next. And again, this is the problem in this context, is that it very much depends on the individual judge in charge and the legal ad or defense attorney if the proceedings, and during the proceedings, the whole case is communicated in a way that makes it possible for the person to follow and to really effectively participate. Here again, the question of training, which not only concerns strict legal training, but also very much soft skill trainings, which I think is also one of the main aims of this project, which I think is really a great approach. And to also really explain what an accessible communication means and how this can be achieved. An additional and an extra point, which is was also mentioned frequently in our project, is that there is a poor quality of legal representation, especially if it comes to legal aid. This area of criminal law is, of course, a very specific one, and oftentimes in some of the countries, the lawyers who were appointed as legal aid lawyers do not even have to be specialized on criminal law. So meaning that persons, of course, who are not familiar with criminal law and then having to take over cases which are already complex in themselves is, of course, not ensuring necessarily a good quality of legal representation. So the question of special ed lawyers, and of course, again, the question of trainings arises in this context as well. And as already mentioned, there is also challenges when it comes to remedies, not only when it comes to procedural rights by interferences and violations at the early stages, but also when it comes to medical expert opinions. So often in countries that were included in this project, it was not possible to really have a second medical expert opinion, even if it was paid by oneself, because this had not the same value as the expert opinion which, from an expert who was appointed by the court. So in our we have identified quite some challenges and also shortcomings, and one of the overall finding in our project was that criminal proceedings against persons with intellectual and psychosocial disabilities bear a particularly high risk of human rights violations due to a number of reasons. And the first one, of course, is that we have already mentioned quite frequently now, is that the identification of this disability takes place at the late stage. And therefore, I think also that this project comes at the time, and it plays such an important role, because I think, first of all, of course, with a timely identification, other safeguards can also be ensured. However, until this timely identification is not ensured for all persons concerned, it's also important that that the procedural rights overall are strengthened in the national context. Because I think there are a lot of safeguards, and especially with the new EU directives, it's very important that these rights are adequately implemented and also transposed into national law. But of course, this is not enough, because as we have heard, it is not enough to have procedural rights, but it's also very important to address the needs of the persons who are in a vulnerable situation. But for that, I think, as this was also mentioned, the criminal law approach has to change. We have to move away from a risk preventive perspective and really focus more on a human rights perspective also when it comes to suspects. And we are not, since the national laws as they are now are not adequately responding to the needs of vulnerable suspects, it is necessary to recognize that persons who are suspects in general might be in a vulnerable situation, and even more so when these are persons with psychosocial disabilities. So I also think that a rethinking of our criminal approaches and our criminal systems is necessary in order to ensure fair trials and human rights. Thank you very much.